All right. Friday, 5 p.m. The documents dropped. And nothing will be the same. Not for the officials named inside, not for the institutions protecting them, not for the constitutional framework that assumed this moment would never actually arrive. Judge Hanks just did what Congress spent 18 years refusing to do. In 72 hours, 3 cabinet-level officials retained crisis attorneys. 12 senior White House staff placed personal assets into emergency blind trusts. The DOJ opened a preliminary tampering inquiry before a single page hit the public record. And the Supreme Court, the highest judicial authority in this country, looked at the executive branch's emergency appeal and said no. Not later. Not after review. No, in 3 hours. That's not a procedural ruling, that's an institutional signal. And if you know how to read those signals, you understand that what happened today wasn't just a document release. It was a detonation. Slow-moving. Irreversible, the kind that doesn't make a sound until the building is already coming down. Here's what I'm going to show you. Not the headlines, not the redacted names everyone's already arguing about on social media. I'm going to show you the structural damage underneath. The careers that ended before the files even dropped. The precedents that rewrote judicial power in real time. The constitutional questions that don't have clean answers and won't, no matter which political side you're on. By the end of this, you won't be thinking about Epstein anymore. You'll be thinking about what kind of government we have left. Let's get into it. Monday started quietly. That's important to understand. Because the people who would eventually hire crisis attorneys on Friday morning, they went to work Monday thinking this was manageable. Contained, 1 judge. 1 motion. Routine appellate pushback. They were wrong about all of it. Day 1. Judge Hanks issues the order. Review of sealed Epstein-related files for potential public release. The justification is direct and unambiguous. Public interest in executive branch conduct outweighs continued sealing. That last phrase, executive branch conduct, is the one that changed everything. Because it meant this wasn't about Epstein's crimes. It was about what the executive branch did to protect them. Day 2. FBI Director Patel moves fast. Emergency motion. National security. The argument is standard. Disclosure damages intelligence operations, endangers sources, compromises ongoing investigations. Attorney General Bondi files a supporting brief within hours. 2 of the most powerful law enforcement officials in the country telling 1 district judge, stand down. Hanks doesn't stand down. Day 3. Both motions rejected. 48-hour compliance order issued. The language in the rejection is surgical. Hanks doesn't attack Patel or Bondi personally, doesn't question their motives on record, simply rules that claimed privilege without specific evidentiary showing, doesn't meet the threshold when public interest in executive accountability is this substantial. Appeals filed immediately to the 4th Circuit. Day 4 is where the physics of the situation changed permanently. The 4th Circuit rules in 6 hours. 6. Normal appellate timeline on emergency executive privilege matters runs days minimum, sometimes weeks. The court did it in 6 hours and denied the stay. The administration rushed to the Supreme Court. The Supreme Court declined intervention in 3 hours. 9 hours. Total, from appeal filed to every judicial exit. That 9-hour window is the number that should keep government officials awake right now. Because it means the procedural runway they assumed existed the time to negotiate, to redact, to quietly reshape what gets released. That runway is gone. 1 judge's order executes faster than any institutional response can organize. Day 5. Today, 5 p.m. files release. Minimal. And the DOJ, the same agency that filed briefs trying to stop this, opens a preliminary inquiry into judicial tampering allegations against individuals who tried to influence the process. The agency is now investigating the people who used the agency to stop the investigation. Sit with that for a moment. There are three categories of people whose lives changed. Most of the coverage is focused on the names in the documents. That's the wrong focus. The names were always going to surface eventually. What matters is what's happening to the people adjacent to the names. The people who thought proximity wasn't the same as participation. Group 1. Current administration officials with zero Epstein connection there are approximately 1. 200 Senate confirmed appointees currently serving. Roughly 3,000 senior political staff across the executive branch. The overwhelming majority of them have never met Jeffrey Epstein, never attended an event connected to him, never signed a document, returned a call, or made a decision touching anything in those files. It doesn't matter. Because in a reputational crisis of this magnitude, the question stops being, what did you do? And starts being, what administration were you serving when this came out? That's not justice. That's not fair. It's how institutions function under sustained pressure. Here's a specific example that illustrates what's actually happening at scale right now. There's a deputy secretary at a major federal agency, appointed in 2025. Exemplary record. Decades of policy expertise. This person's name appears nowhere in any Epstein-adjacent document because there's nothing to appear. Clean record. Real competence. One of the people government service is supposed to attract. This week, 3 job interviews were quietly canceled. No formal explanation. Just we need to wait for the situation. One board seat a position this official had been informally offered pending their government departure is now on indefinite hold. A hospital network that was actively recruiting them for a CEO role has gone silent. Nothing was alleged. Nothing was found. The association alone is costing real consequences. And here's the structural problem that outlasts this news cycle. Every Senate confirmation hearing for the next decade will include questions about this period. Did you have any involvement with matters related to the Epstein files? Becomes a standard line item. Officials who served in good faith now carry an asterisk that follows their career permanent. Government service, which was already a financial sacrifice for most talented private sector candidates, just acquired a reputation tax that didn't exist 6 days ago. Group 2. The career DOJ attorneys who handled the original case, these are the people nobody's talking about. And they're the ones facing the most consequential personal exposure. 14 career prosecutors directly touched the 2008 plea agreement and the sealing decisions around it. 40 plus supporting staff worked the edges of those decisions over the years. These are not political appointees. They're not ideologues who took the job to advance an agenda. They're career civil servants who executed decisions made by supervisors appointed by presidents of both, following protocols that legal leadership signed off on at every level. They followed lawful orders. They documented their decisions. They moved on to other work. Some of them retired. Some are still in different districts doing completely unrelated prosecution work with unblemished records, spanning nearly 2 decades since that plea agreement was finalized. And this week, those people retained personal attorneys. Not because they did something wrong, because they suddenly understand that doing something legal under supervision in 2008 doesn't protect them from criminal review in 2026 if the political climate has shifted enough. That's the mechanism that's breaking something fundamental in how government functions. The implicit promise of institutional service has always been, follow the rules, follow your supervisor, and the institution protects you. That promise just became explicitly unreliable. One career attorney, GS 15 level, different district, 18 years of service since that case, is now under internal DOJ review. Same agency reviewing them is the agency that directed the decisions being reviewed. They've retained private counsel using personal funds. Their pension, which they earned through nearly 2 decades of federal service, is now potentially at risk if the review results in a misconduct finding. They followed orders. That's not a defense anymore. That's the problem. Group 3. Federal judges who ruled on Epstein matters over 18 years, 8 federal judges with direct involvement in Epstein-related cases, appeals, or civil matters across the timeline of this saga. They assumed something that turns out to have been an assumption rather than a fact, that judicial immunity meant permanent insulation from consequence. Judicial immunity protects from civil liability. It does not protect from impeachment. It does not protect from historical, and it does not protect from what happens when sealed documents reveal what a judge saw, knew, or chose not to question when they had the opportunity. If today's document release shows that prosecutorial teams presented misleading information to the district judge who approved the 2008 plea agreement, and that judge didn't push back with the scrutiny the record warranted, that judge's legacy permanently, publicly, irreversibly, there's a senior district judge, now 71, semi-retired, whose career until last Monday represented the kind of judicial record that gets cited respectfully in law school courses. If the unsealed documents tell a different story about what that judge was shown and what questions weren't asked, that entire career gets recontextualized in one afternoon. 71 years lifetime of service. Legacy determined by what was in files a district judge in a different case decided the public needed to see. That's where we are. This is the section that matters most. Because the officials named in documents, the careers disrupted, the hearings that will dominate the next news cycle, those are real consequences. But they're finite. Eventually they resolve. People are charged or not charged. Hearings conclude. Administrations change. Precedents don't resolve. They compound. Precedent 1. District judges can override executive privilege on public interest grounds before this week. The operating assumption across the executive branch was that national security claims and executive privilege assertions created a substantial procedural moat. Courts generally deferred to executive expertise. A district judge going up against the FBI director and the attorney general in the same motion and winning that wasn't in the institutional playbook. It is now. Hanks established that a clearly articulated public interest standard in executive branch accountability can outweigh claimed privilege without specific evidentiary showing of damage. The Fourth Circuit affirmed it by denying. The Supreme Court ratified it by declining to intervene. Every federal judge in every district now knows this is possible, defensible, and survived every appellate challenge thrown at it. The next time an executive agency seals documents that are embarrassing but not genuinely sensitive, and it happens more than anyone admits publicly, a district judge has a tested roadmap for forcing disclosure. The executive branch can't argue this precedent doesn't exist. It does. They created it by losing. This one is underappreciated because it sounds procedural. It isn't. It's a fundamental power shift. The executive branch's tactical advantage in document disputes has historically been time. Emergency appeals by days. Procedural motions by weeks. During that time, administrations negotiate, redact, compromise, and often reshape what eventually becomes public. The process protects the powerful by being slow. 9 hours. That's the new timeline. Fourth Circuit, 6 hours. Supreme Court, 3 hours. Total appellate review from filing to final denial, 9 hours. What this means practically, when a district judge issues a sealing order going forward, the executive branch has approximately 1 business day to comply before contempt exposure begins. There is no longer a procedural runway long enough to protect sensitive decisions through delay. The tools that made institutional defense viable are gone, and no legislation changes what those 9 hours proved about appellate urgency when courts decide they want to move. This is the one that will hollow out government capacity over the next decade if it isn't addressed. Every career attorney, every policy official, every civil servant making consequential decisions under supervisor direction now has to operate with an awareness that those decisions may be criminally reviewed 15 or 20 years later under an administration with completely different political incentive. The protection of institutional service, follow the chain of command, document your reasoning, trust that the organization protects career staff who performed properly just became explicitly conditional. Conditional on political climate. Conditional on which administration is in power when someone decides to look back. Conditional on whether the precedent Hanks created gets expanded or constrained by legislation that may or may not pass. Career government service has always attracted people willing to sacrifice private sector income for institutional stability and mission. It never before asked people to sacrifice institutional protection as well. It's asking now. Hanks just established that sealed means sealed unless a future judge decides public interest warrants otherwise. There's an active cooperation negotiation happening somewhere in the federal system right now where a potential informant is asking their attorney a simple question. Can the government actually protect my identity long term? Before this week, the answer was clear. Now the answer is legally complicated. That complexity kills cooperation. That cooperation collapse affects prosecutions that have nothing to do with Epstein, with the administration, with anything in those files. The collateral damage extends into criminal justice infrastructure that took decades to build. The intelligence sharing collapse this one is classified, so it won't make the news cycle this week. But diplomatic sources are confirming something significant. Five Eyes intelligence partners are reviewing, and in some cases pausing sensitive information sharing with U.S. agencies. The reasoning is direct. If U.S. courts can unseal documents containing Allied intelligence based on domestic public interest determinations, sharing sensitive information with the U.S. creates exposure for Allied operations. The judicial system just demonstrated it's capable of overriding executive assertions in ways those allies cannot predict or plan around. Intelligence partnerships run on predictability, on the certainty that information shared in confidence stays in confidence, except under the narrowest, most controlled circumstances. Hanks's precedent introduces uncertainty that Allied intelligence services can't absorb without adjusting their sharing protocols. The foreign policy damage from this precedent may outlast every domestic consequence by years. The question nobody wants to answer here is the actual constitutional question at the center of everything that's happened this week. Not did Hanks have the authority. That's been answered. The authority existed and survived every challenge. The real question is, should a lifetime appointed unelected district judge be making political accountability decisions that 535 elected officials spent 18 years actively avoiding? Congress could have held Epstein hearings in 2010, in 2015, in 2019, in 2022. Both parties held majority at various points. No hearings happened. No serious investigation was mounted. Elected officials with direct oversight authority and democratic accountability chose repeatedly not to exercise it. One unelected judge decided that was sufficient and did it themselves. If you believe accountability required someone to act and courts were the last option standing, Hanks is an institutional hero who used available authority to deliver what democracy failed. If you believe unelected judges substituting their judgment for elected congressional oversight is structurally dangerous, regardless of outcome, Hanks represents exactly the kind of judicial overreach that erodes democratic legitimacy over time. Both of those positions are coherent. Both have serious constitutional grounding. Neither And the tension between them doesn't resolve when the documents drop. It deepens. Scenario A. The transparency cascade probability 20% Hanks's precedent gets embraced by district judges nationally. A transparency wave builds. Sealed government documents from the past 30 years become contestable through public interest claims. Decades of institutional conduct becomes visible in ways that would have been unthinkable 10 days ago. Who wins? Transparency advocates, investigative journalists, citizens who've operated without visibility into consequential institutional decisions. Who loses? Government operational capacity, witness protection programs, intelligence sharing relationships, and the basic ability of the executive branch to have any internal deliberation that doesn't eventually become public record. Why only 20%? Most judges are institutionally cautious. Following Hanks into territory this contested requires individual judicial courage that the profession systemically selects against. The more likely pattern is other judges watching, waiting, and treating this as an outlier. Scenario B, the legislative course correction probability 50% Congress passes bipartisan legislation clarifying judicial authority over sealed executive documents, establishes standards that prevent both executive abuse of sealing authority and judicial overreach in unsettling legitimate confidentiality protections. System stabilizes with explicit rules replacing the assumed framework that this week shattered. Who wins? Congressional oversight appropriately restored? Executive branch operating under predictable rules? Judicial legitimacy preserved because the conflict resolves politically instead of constitutionally? Who loses? Hanks personally? Whose precedent gets legislatively narrowed? Radical transparency advocates who wanted unlimited judicial unsealing authority going forward. Why 50%? Historical pattern is clear. When federal courts move in ways that both parties eventually find threatening to their institutional interests, Congress finds the bipartisan clarity to constrain the courts. This situation threatens both parties' ability to protect their own administrations. That shared vulnerability usually produces legislation. Scenario C. The constitutional confrontation probability 30% documents drop at 5 p.m. and reveal conduct serious enough that criminal exposure is immediate, obvious, and inescapable for multiple senior officials. Administration calculates that compliance with further Hanks orders is politically more damaging than open confrontation. Defiance of judicial authority begins. Constitutional crisis escalates past the point where scenario B remains available. Who wins? Nobody. Constitutional crises that reach the level of executive branch defiance of court orders damage every institution, regardless of which side is ultimately vindicated. Who loses? Rule of law itself, regardless of which branch blinks first. Public trust in government, which was already fragile, fractures in ways that take a generation to rebuild. Why 30%? The only thing that makes scenario C viable is if the documents are damaging enough that the administration has nothing left to lose by fighting. Right now, that's unknown. At 5 p.m., it stops being unknown. The content of those documents determines which of these scenarios we're living through by Monday morning. Tonight, 5 p.m., the document. Read what's actually there before accepting anyone else's characterization of what's actually there. The framing war begins the moment they drop. The actual contents and the media characterization of the actual contents will diverge almost immediately. Sunday talk shows watch which administration officials appear and what posture they. Officials defending the administration's position suggest scenario B. They believe this is survivable through normal political process. Officials who are conspicuously absent suggest scenario C. Preparation is happening. Monday, 9 a.m. Market open. Markets price scenario probabilities better than political pundits in most institutional crisis situations. Significant downside volatility Monday morning indicates scenario C is being taken seriously by people with real money on the line. Next 30 days, watch for 3 specific signals. Criminal indictments from the tampering investigation indicate how serious the underlying misconduct actually was. Bipartisan legislation introduced in both chambers indicates Congress moving to take back authority before more judges follow Hanks. Judicial Conference formal statement on the unsealing precedent indicates whether the federal judiciary plans to treat this as isolated or replicable. End of 2026. By December, we'll know definitively which scenario won, whether Hanks becomes standard practice or precedent outlier, whether the executive-judicial relationship was fundamentally restructured or returned to prior equilibrium, whether government service became permanently riskier for talented people, or whether enough institutional memory was preserved to maintain the talent pipeline. Epstein's crimes are not the story anymore. They haven't been the story since Monday, when Hanks issued the first order. The story is whether a single district judge just permanently altered the balance of power between branches of government that have operated under a set of assumed arrangements for decades. The story is what happens when elected officials repeatedly refuse to exercise oversight authority, and the judicial branch decides the resulting accountability vacuum is their problem to solve. The story is whether government can function, can attract talent, can maintain confidential deliberation, can build the cooperation infrastructure that enforcement depends on if every internal decision operates under the assumption that it will eventually become public. That question doesn't have a comfortable answer. The Epstein files are the trick. The constitutional architecture is what's actually being stress tested. And the test is happening in real time, faster than any of the institutions involved can thoughtfully respond, under political pressure that guarantees at least some of the responses will be driven by panic rather than principle. By Monday morning, we'll know whether this week was a historic transparency reckoning or the beginning of a constitutional confrontation that makes every other political crisis of the past decade look like a policy disagreement. One judge, one order, one decision to say enough. Whether that was heroic or dangerous depends entirely on whether the institutions it disrupted were worth protecting in the first place. We're about to find out. Stay with this. Because the documents are just the beginning.